Mr. Foreman, and ladies and gentlemen of the jury, you will recall that at the commencement of this trial, I made a few brief remarks to you about how important it was, under your oath, to listen to the evidence and be attentive, of course, to the arguments and to the charge of the law by the court. I further reminded you, at the commencement of the trial, of the oath which you took, and I stated that in the normal and ordinary course of business, and in the normal and ordinary course of our lives, we accommodate the people that we meet in the street, our neighbors, people with whom we do business, our friends. I stated further that today you and I are not on a normal pursuit of our lives. We are here today under the solemn oaths which we have taken to do our duty and to see that justice is done in this court. I am sure that you have noticed here today that some people, of course, as I have told you, or during this week, they referred to me as Your Honor. They do not speak to Jane Quinn when they say that. They speak of the position which I hold, because as I sit here presiding over your court, as your circuit judge, I hold in my hands the honor of the state of South Carolina and the county of Fayette. And when you took the solemn oath which you have taken and became the triers of the facts, as you have become in this case, you must share with me that responsibility. And now you hold in your hands the honor of your county and our state. And I would not have that soiled, nor would you, I am sure. Now, I want to commend counsel, both for the state and for the defense, for the commendable job that they have done exercising their duties and responsibility under the law. Both have done an exceptionally good job. As I told you earlier, that this indictment here, and I will not read it to you completely, is not evidence and not to be considered by you as evidence. To this indictment, the defendant, G.S. McLeod, has been indicted for murder, and the charge of murder, of course, includes the two lesser offenses of voluntary manslaughter and involuntary manslaughter, which, of course, I will charge you the law later on in my charge. Now, to this indictment, the defendant has pled not guilty. And when the defendant pled not guilty, that placed the burden upon the state to prove his guilt beyond a reasonable doubt. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent, because in many instances that might not be possible. I charge you further that it is a cardinal and important rule of evidence that the defendant in a criminal trial, that no matter what the enormity of the charge made against him may be, will always be presumed innocent of the crime for which he is indicted until his guilt has been proved by evidence satisfying you of that guilt beyond a reasonable doubt. Now, ladies and gentlemen, this presumption of innocence does not cease when you retire, but it accompanies the defendant from the time of his appearance or arraignment throughout the trial, and until you have reached a verdict of guilt based upon the evidence, satisfying you of that guilt beyond a reasonable doubt. Now, our Supreme Court has said that the presumption of innocence is like a robe of righteousness. placed around the shoulders of the defendant, and it remains with him and assigns him to that class, the innocent, until that presumptive robe of righteousness has been stripped from his person by evidence satisfying you of that guilt beyond a reasonable doubt.